Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. Again, Tuesday, April 28, 2026 at 3:25 in the afternoon. Continuing our conversations on S71, and we have Attorney General's office. Thanks for coming in. Appreciate your time.
Good afternoon.
Good afternoon.
For the record, Todd Dalos, Assistant Attorney General. Good to be back. I thought it's been a couple of weeks. I think you've spent a lot of time today already on data privacy. So I want to stay pretty high level with where we sit on this bill. I think it's no surprise to this committee. We are in full support of increasing the data privacy and data protections for Vermonters. We think this is one of the forefronts of consumer protection law. And I want to throw two little anecdotes out about data privacy and data protection from very different ends of the spectrum, but I think it really distills a lot of the work this committee is focused on and what S71 really gets at. I would say H211 work it did first half of the session also. So the first is I was just standing in the cafeteria, as people like me are wont to do, and a friend who works in the building came up and they said, hey, listen, unrelated to any work on data privacy, they said, I've been trying to sell this property, rental property, and it fell through, and we've been talking about it for a couple of months. And they said, so now I'm looking at trying to get a home interest loan, line of credit, to do some renovations on the place and make it a nicer rental property. And they said, but the day after I spoke to the financial institution about seeking a high interest home equity line of credit, I started getting calls on my cell phone. And at first I thought these were financial institutions. Maybe they were underwriters. Maybe they were doing a background check. And this person said multiple times they had to push to get it clear from the other entity who was calling them that the other entity was in fact competition with their potential home equity provider, seeking to undercut them with a better loan rate or otherwise. And finally, this person said, hey, listen, how did you get my information? And then one of these entities said, oh, you can buy this stuff right away. At which point I said, you should come sit down and testify in front of the Congress committee about data privacy, and you should probably go downstairs to the Senate and talk about data brokers. My only point there is, right, that was a conversation with a colleague not related to data privacy. That was completely about data privacy. The second one goes down to Washington, D.C. Yesterday, the U.S. Supreme Court had oral argument about government reliance on data as a means of expanding, some people would argue, avoiding the Fourth Amendment, right? So this is a case that had to do with geofencing, geolocation data. It was a case pretty brutal. Actually, I don't know how brutal the underlying crime was. That's the interesting thing. Just a quick side note, when you get all the way to the Supreme Court, the facts of the case become way less important than the theoretical facts of the case to provide support for the law. But in this case, the issue was a bank robbery, I believe, and law enforcement didn't have any leads, and they reached out to get geolocation data around the bank for 30 minutes and basically sorted through everybody whose cell phone had pinged to figure out who might be a suspect for this crime. Now, maybe at the end of the day, that ended up in the right place, if we believe in that view of justice. I think there's another world in which there were probably 99% of the people caught up in that geolocation search who had done nothing wrong and had had their data subjected to government and law enforcement review. So all of those are data privacy issues. And I don't take a necessary position on the Supreme Court case, but I just want to say you're in the right moment and you're focused on the right things. From our perspective, S71, as it has been amended in this committee, or is proposed is moving in the right direction. I think I'll save my last point because you already know what it is about enforcement. But upfront, I think we support consistency of definitions across the board. We support a working, meaningful data minimization standard, especially one that has some reliance on sister states and therefore is a little easier for the regulated community to respond to. So all the, again, I can come back and provide more detail as you wish. Perhaps when the day is not weighted with such anticipation for 4 o'clock for various reasons. I will just say about enforcement. I mean, I have said it for this committee in the past, and I will continue saying it. From our perspective, the history of Vermont is strong and meaningful. We have provided individuals the ability in the consumer protection space to seek their own remedies. And where necessary, the state can step in when there is a pattern in practice or broad scale harm done. That's the right role for the Attorney General. So I'm happy to answer questions, but I will continue pushing for the status quo in the world of consumer protection, and this is a consumer protection.
Any concerns about funding, having to deal with all this stuff?
Yeah, as drafted. So, again, I want to say if there's a private right of action, that democratizes and socializes the cost, right? Consumers can bring their own actions. That's going to move the law in directions. That's going to provide pressure on industry to comply and be more compliant. Because remember, if the industry is compliant, by and large, you're not going to have actions that cost you money significantly. If it does sit with the AGO, I think that's a very heavy lift for under the existing resources. I just don't think it's tenable. With new resources, I think we'd have to see, and there's a very real likelihood that we'd come back and need more support if it ended up with us. And again, I want to say our position is that the status quo should remain. We should continue the path of 58 years of consumer protection in Vermont. But if it were to shift, resources are a real concern. And I think if there aren't resources, then it's really hard to say that we've got a law that's going to move the needle for them. Sure.
Yeah, so I looked at market capitalizations for Meta and Alphabet.
Oh, yeah.
And Amazon. We're looking at 1.7 trillion, 4.22 trillion, 2.79 trillion, which sort of frames it for me in terms of you got to buy, I don't know what limited.
18.
Yeah, and you got a bunch of good attorneys, investigators, that kind of thing. A lot of, and so I'm just trying to imagine a world where you don't have that private right of action for people to, try to do that, and it's left on you. And I'm wondering how you're going to manage that. And I know some of the ways that other regulatory agencies in Vermont do that is they have the ability. It's particularly sort of the prejudgment costs. And my sense is that a lot of these types of investigations and litigations take a while. So you got to be able to have the resources to do it. You can recoup your costs, in the final judgment, which is success. I'm just worried about before that, your expenses and the time that I can imagine, trying to litigate against someone like Meta or something. It might take a while. And whether you think some type of arrangement where you can bill the regulated entity for the costs of your examination and investigation would be helpful.
Yes. Thank you. I would say a couple things there. One, not worried about fighting the big guys. And I would say if the Attorney General was sitting here, I think you would hear her say even louder and more clearly, she is ready to fight them. And, we have a history in Vermont. When former Attorney General Bill Sorrell sat in that office, he was a big advocate against big tobacco. And that, just yesterday, I think, maybe it was earlier, it was a couple of weeks ago, we got this year's master settlement agreement payment of $22+ million for Vermont, right? That's the result of fighting major industry that does significant damage. I'm not saying data privacy quite sits with big tobacco, but there's overlap. And Vermont is able to punch above its weight. And we certainly have every faith in our office that we would be able to do that. That said, figuring out some system to equitably cover those, especially as you say, pre-litigation investigatory costs, I think is really important. I think when it's a regulated industry, it is appropriate for the cost to be borne by the regulated industry. And depending on how the bill shakes out, I think we want to be thoughtful on whether the AG is going to be charging a small, mid-sized Vermont company the same rates that it's going to be charging one of the richest corporations to ever exist.
Yeah, so just following up on that, I mean, can you imagine some sort of threshold where that might be appropriate to charge back and below that it's not?
Yeah, it's definitely possible. I think there's more detail in there around, there's also administration around chargeback that requires positions and that, I think it is an area worth engaging further on. And I think the private right of action solves.
Thank you.
I can stop saying it.
And maybe it's good that we're talking about that because America loves an underdog story. But I don't know if it's all gonna be, is it all gonna be AGV like meta? I was wondering about who else would get caught up in some sort of a track or something that is this where we want to direct all our efforts? And I think maybe what I'm anticipating is that your comment might be that's what the area is for. So as to separate out what we might not have time for or what might be at a different scale than we want to direct, our mumbled million budget that I heard earlier into. But I guess that's is this about, I mean, is the enforcement mechanism about big game hunting?
It's not quite. I'm tempted to say yes, but I'm not going to, or at least I will qualify that yes by saying, think of, if we fast forward to the end of the story and here's the settlement or the judgment against the company, that dollar figure is a proxy for the harm done to Vermonters. And so what we look at is what is the scope and scale of the harm? And yeah, a company that holds the data of 400,000 Vermonters, 500,000 Vermonters is probably going to do a lot more harm if it's an unfair and deceptive practice or otherwise violates the law. That's the kind of entity we would mainly focus our research on, more so than a small scale company, a retail outlet in Vermont that may or may not hold 25,000 Vermonters data. We are going to be balancing those.
It's how do we separate out those entities that rely on products and services to have from the big fish from, I can imagine with their market capitalization rates and according to big, I guess white shoe, what is that oh no, that was on the business.
Yeah.
They made the choices. I mean, it feels like maybe I don't have the guts of the AGI exposed to what I'm just getting at, but I'm wondering if is that clear though in the way that it wasn't, I don't believe it was ever posited that big tobacco would blame the convenience store for selling the product.
So in a hypothetical world, I think sometimes the retailer does get blamed for the marketing. So S198, you had that here a couple of weeks ago, right? One of the big pushes within that bill is ensuring that the marketing, whether it's the deceptive devices or otherwise, that really focus on youth. The folks doing that marketing, bringing those products into market, those are the folks who we should focus on, not the kids who end up buying. So I think there's a little bit of an analogy there. You're talking about the back end data servicing companies that maybe your small catering company may hire or otherwise. At the end of the day, I think if I were imagining what that investigation would look like, we would get some kind of complaint. We'd probably get a bunch of complaints, assuming that we're the only enforcement entity. And we'd have to determine, are we going to go after, Cooper's Catering and determine that it's, you've reached the thresholds, the law applies. And then we send out a civil investigative demand. So that's like a list of questions, send us some documents. And then we look, and probably in those responses, you'd be like, well, we use XYZ data processing service. And that's when we would get into a conversation around, well, we may be pulling them in. Again, we do that in other consumer contexts. But largely you're gonna have that Cooper's Catering is gonna have contract with that data provider and, you know, they're gonna have to work out liability and things like that, but we're gonna come in and really look at, are there violations of data practices? And if it turns out that the contractor is violating, then it's likely that contractor has contracts with other Vermont businesses. And if they're violating for Cooper's Catering, then we're gonna look everywhere else too. So it's gonna expand up from there.
Thanks, Todd. Appreciate your testimony. I have questions around rulemaking and the report. I'm gonna do the report because I think it's easier. We're looking at a February date annual report, and I worry that that doesn't align with legislative updates and rulemaking, and I'm wondering if a November date or something like that makes more sense if we're looking at it on some kind of annualized basis or September, I don't know, you tell me, but just thinking about it from
Yeah.
that perspective.
I think you're right on. November, December is usually better. December. I mean, I feel like I'm talking to people who actually, you know, I come to you with a report and say, boy, we should put some legislation together on this. And if it's after the deadline, then we are where we are. So I would say yes, earlier than that is better. There's no ideal time because it would depend on exactly how. I think fall is good.
Okay, we'll get on some kind of cycle and then it will be fine, but changing it to a fall date works.
I mean, I'm not aware of why it might be February otherwise.
Okay. Yeah, I don't know either. And then rulemaking, do we need dates around that? Do we need, I mean, obviously the bill can't go into effect July 1 of this year. That's just, nobody would be prepared for that. But would you want to have a year? Would you want to have 2 months? Like, you know, just, and you can come back to us, but I would
Yeah.
just love some thoughts on that.
Happy to give you thoughts and would love to come back with a little bit more mapping it out, but I will say this, so age appropriate design code, kids code, right? When you passed that last year, you gave us 18 months to put rules together. Those rules, I think, will be ready for preliminary draft publication within the next month. That'll be an opportunity for industry to weigh in. We've done some preliminary rule outreach, just saying, hey, what do you think should be in these rules? We got some comments, we've incorporated those, we're gonna put out a draft. So that's an example of an 18-month. It hasn't been quite 12 yet, but we anticipate 6 months of actual Vermont APA, Administrative Procedure Act rulemaking. So looking at a July filing. As far as rules for this, I'd want to look a little bit more in detail and think with the team about what we think it would take to implement, but. I mean, yeah. Lawyers love deadlines and it'd be great not to necessarily have deadlines.
Well, reasonable deadlines. We want reasonable deadlines.
Other questions about? Great,
Thank you all.
thank you, Todd.
Happy to come back.
So any discussion on what we heard today?
What's the discussion about?
Or is there any discussion of what we heard today?
That's what I thought.
Yeah, I'm pretty comfortable with it so far. I don't feel like we've heard a whole lot from the business community. I don't think we hear
Yeah.
more, but
I think we're proceeding pretty well. It's real fascinating. And looking forward to hearing everybody else.
Good. So tomorrow, I'm here at 9 o'clock. Continued discussions on S71. Tomorrow afternoon, we'll take a little break and get an update on the UI trust fund. That's something we have to do every year. And then we'll have more testimony on S71. So if there's nothing else, we will, it's done today. We'll be back here